Hey everybody, how's it going? Hope you're having a lovely day. Welcome to today's episode of How You're Getting Fucked, but today not really because of a base judge. I'm your host, Louis Rossman. Today we're going to be discussing this law that I talked about 2 months ago, a Texas law that requires age verification for application downloads. In this video, I'm talking about this horrible law that made its way through the Texas State Senate. This is an age verification law that would require, if you want to be able to download applications on your phone, you're going to have to go through some sort of age verification system in order to use things like the Google Play Store or the Apple App Store, and this law got smacked down for great reasons by an awesome judge, and we're going to read why. To give you a recap on this law, if you didn't see my original video, the way this is set up is if I went through the age verification process, I can download whatever I want. But if I am a teenager, I have to ask my parents not just to download certain types of apps, I have to ask my parents every time I want to download anything. So let's say that I download a dictionary. I have to get approval from my parents. But the way this is written, if I then want to download a thesaurus, I then have to bug my parents again because the law is explicitly written to not allow blanket approval for certain categories. You're not allowed to approve applications approved for kids under 13 that help them in English class. You're not allowed to approve calculators. You're not allowed to approve school stuff. You're not allowed to approve weather apps. Every single application would require a separate one. And what makes this even worse is that the law's broad definition of the word App Store could apply to the Google Play Store and App Store, but also to F-Droid, and even GitHub. The way this is written is so bad that this could potentially even apply to repositories like the Debian. So if you use Debian Linux and you do apt update and then you go apt upgrade, the way this law is written, it could apply to that as well. It functionally destroys the entire way that any of this works. So this pinned comment that I have, what are they going to draw the line? If I use Discover on KDE, does that count as an app store? What about a CLI package manager? Do I have to build everything from source? Does cloning a Git repo violate this? And these are all questions that are not answered by this very, very poorly written law. And the judge seemed to acknowledge this very quickly, and I'm happy that he did. So I want to read the parts from the judge's statement, which is about 20 pages long, that were the most important to me. The act is akin to a law that would require every bookstore to verify the age of every customer at the door, and for minors, require parental consent before the child or teen could enter, and again when they try to purchase a book. As set out below, the court finds the likelihood that, when considered on the merits, SB 2420 violates the First Amendment. True. Imagine if your parents say, okay, fine, you can go in the bookstore, but then before you can take any book off the shelf, you then need your parents' approval yet again every single time. It's a lot of meddling for a state that values or prides itself on not meddling in business. Next is how broadly this applies when it comes to the different types of applications here. It applies to everything. Again, not just X-rated apps. It's not like the Texas law with porn having age verification. This is just age verification for everything. Paxton gestures generally to the impacts of social media on youth and calls the apps a health hazard. At the hearing, Paxton suggested too that the interest underlying the law was mitigating the impact of excessive phone use and overall screen time, algorithmic targeting, and artificial intelligence on youth users of social media, which again, I'm not against. However, but nothing in the record suggests, for instance, that teens suffer from mental health disorders from using a dictionary or a weather app, even though those apps are age restricted and subject to parental override under the act in the same way as social media. Because it bans minors from downloading apps and content from all apps, not a narrowly tailored subset of apps deemed, for example, harmful or addictive based on evidence, the law is more over and under inclusive than HB 18, which this court previously enjoined. And if you want to say that you're trying to protect children, but then I need approval to download a dictionary or a weather app, which are things that are accessible via the web browser, which you do not need age approval for, this just becomes functionally ridiculous. I can go to dictionary.com on a stock iPhone without parental consent. The act holds app developers and app stores liable for knowingly misrepresenting an age rating, but fails to provide meaningful guidance to developers and stores about what metrics should be used to determine the age rating of an app. SB 2420 is silent about what content is appropriate or inappropriate for each age category. Developers and stores could follow existing non-governmental standards, yet following those standards may not be sufficient and could lead them to violate Section 121.021. B. The portions of the act that hold app developers and stores liable for getting age ratings wrong are impermissibly vague. Then we have to deal with the unintended consequences, which again, legislatures that lean more conservative are usually more aware of, and I was surprised that they were not thinking about this here. They usually talk about every time you add a regulation, there's going to be an unintended consequence. The way this law is written is something would have to be age verified again each time that you make an update. So this means that you are now going to create an incentive structure for companies that want people to continue using their applications to put out less updates. updates. For example, Google explains that the Act's requirements may deter app developers from appropriately updating their privacy policies or terms of service, making safety and functionality updates, design modifications, interface improvements, and new content offerings, because each of these changes could require burdensome new disclosures and millions of minor users to again obtain parental consent. And again, when it comes to the law, if there is a chance that by not obtaining parental consent I get in trouble, but that goes away if I obtain it, you're either going to do less updates or you're just going to constantly obtain parental consent and annoy people. Neither of those is good. You're creating a system where people have less incentive structure to actually update the applications and keep them working well because they do not want to get in trouble. Analogizing to tobacco or alcohol use, Paxton argues that Texas has an interest in regulating products and services which pose health hazards or which may be addictive to minors. However, the state does not cite evidence to substantiate the assertion that downloading an app of any kind without parental permission poses a health hazard to minors. That argument gestures towards Texas's interest in preventing social media addiction, but SB 2420's coverage sweeps far wider. All apps are restricted beyond social media as described above. So too, SB 2420 does not limit its scope to apps that use addictive algorithms designed to encourage prolonged use or apps that are responsible in particular for causing excessive screen time. As one example, SB 2420 restricts access to apps that seek to promote physical or mental health, such as mindfulness apps like Calm and fitness apps like Strava. Also problematically, the law is under and over-inclusive. That a law is wildly under-inclusive when judged against its asserted justification is alone enough to defeat it. The law is under-inclusive. SB 2420 specifically cuts teenagers off from wide swaths of the critical democratic form of the internet, even though the same content offered via apps remains available to minors via pre-downloaded apps like Safari or in stores. Again, true. You're saying that I can't access a dictionary or weather app or anything else, but simultaneously I can access all that stuff using Safari, which is included on the phone, and then many things that you may not want me to be able to have access to begin with, which then brings into the conversation, well, use parental controls or parent your children. And once you get into the conversation of why don't you just parent your children, and then once we get into that conversation of parental controls and having some idea of what your kids are doing with their devices, it makes me wonder, why are we doing this? The provision also likely incentivizes over-censorship, as app stores may broadly revoke access to avoid liability and steer wide of the unlawful zone, which further threatens to restrain speech. I like this judge, at the very least from this. I haven't read the rest of his opinions yet, but from going over this, I think this is very, very fair. And one of the things that's most disappointing to me here is I worked for somebody for 3.5 years that was the co-founder of WhatsApp. He's creating a lot of applications now. He's a great programmer. He made Yahoo Games, and he is employing over 50 people here in Texas, and he's about 5 or 10 minutes drive away from the capital. And there are many people like him that are here that would love to provide some sort of input on, at the very least, if you're going to do something that is going to negatively affect us, here's how you may be able to do it so it's not a mess. Here's how you could do it so that this could not be potentially applied to Debian apt-to-get updates so that it just doesn't destroy everything. I was going to throw it out there. There are at least 8 people over the last year that have contacted me from the Texas House and State Senate over the last year on a number of different issues. And I've showed up every single time. I'm more than happy to sit down and talk and give my opinion about a number of different items. And it would be nice to be able to provide some input on items like this so that even if you're going to do something that I think is lame, is done in a manner where it's not really destroying large swaths of business. The person I'm referring to lived around Palo Alto, California, and now he lives here. He moved here because he does not want to deal with this. A lot of people move to Texas for business reasons, and I do know several people that are substantial app developers with many more zeros in their net worth than me that moved here, that want to create here, and something like this is going to make it infinitely more difficult. It's going to make it more of a pain in the ass. I'm glad that the judge struck it down. And again, my inbox is always open if people want to actually engage back and forth on this. You know, when it came to the porn age verification thing, like it's one of these things where I don't agree with it, but I can kind of at least see where you're coming from. This, I don't. I really don't. Anyway, that's it for today. And as always, I hope you learned something. My inbox is always open. Reach out anytime. See you in the next video. Bye now. Next up, I wanted to ask if you could help us out with consumerrights.wiki. This is totally unrelated to the topic of today's video, but I'm trying to build this out into the best thing I can. This is a website that is a centralized repository of every time that a company has screwed over users and tried to revoke ownership or change the terms of the sale after the sale. One example of this is with Nixplay. Nixplay made picture frames, and they advertised these picture frames as unlimited upon purchase, but many of the features that you had access to were then hidden behind a subscription later on. They changed the terms of the sale after the sale. We want to make it so that people have a centralized place they can look to find out when a company has done this, and more importantly, be able to understand that company's history before purchasing from them in the future without having to check the wiki. Well, we have a wiki that has all the details, it has what they send the customer, it's well cited, and it's all curated by the community. A lot of people may not use this. So we're making a browser plugin that when you're on a company's website, if you're about to buy one of these products, it will automatically tell you a little warning, and then it will give you a short description that will tell you what that company has done with a link to click on if you want to read more about it at the wiki. Now, in order to do that, every single one of these articles that you see needs a short description. So for instance, if I'm looking at the Hauptwerk expiration of perpetual license download page, I click edit source. When I click edit source, there's a description field up here in this cargo template. Description: perpetual license software not offered for download in spite of link saying never expires. So if somebody is on their website to download or purchase their software, the browser plugin would show them a warning with this description, because I'm not just going to spam them with the entire article. There needs to be a TLDR. This article over here does not have that. If I edit Nixplay's article, you'll see that it does not have a description tab. It is not as complete. So what we're looking for are people that can go through all the articles on the wiki and then add these tables if you have the ability or the time to do so. So if you don't have the time to write articles from scratch or do research, here's some low-hanging fruit that you can do, because many people have asked us how they can help. So when you look at this page that I'll link below, projects, cargo, you'll see that there's a list of different articles, and some of these articles have descriptions, but some of them don't. And if you see articles that don't have descriptions, or you see articles that have descriptions but they could be a little better, it would be exceptionally helpful if you could go to those articles and then edit in those cargo tables. If you're not sure what it's supposed to look like, you could look at a page that has a proper cargo table and use that as a template. You go edit source over here, and you can see the way it's supposed to look and use that as a template for yourself. Keith is more than happy to help with any questions. He is employed by the Consumer Rights Wiki and Fulu Foundation. You can email him at keith@consumerrights.wiki. That's keith@consumerrights.wiki, or you could find him in the Discord that is below. There is another project that we could also use help with over here, which is creating archival links. Many of these pages are linking to pages on company websites that they may scrub once they figure out that these pages being up gives them bad PR. That's why it's very important that we not just use a link to that company's website or a news article, but that we also include web archive links. So when you are adding links and citations to the wiki for all these different articles we have, it asks you, do you have a link and do you have an archive link? And admittedly, a lot of the times I'm writing an article, I have a lot to do already. I may not have the time to add an archive link, and many don't add an archive link. What we're looking to do is find people, and I'm going to link to the project page down below, that are willing to go through all these articles and then start adding archival links for the links that are there. This is, again, going to be quite a bit of a project. You'd have to go through pages like the one that I have here. Let's just go over this Hauptwerk page. Let's click on edit, and I'll show you what that looks like if I try to edit links themselves. So let's say I click on this, number 3, I click edit. Actually, never mind, that's an email correspondence. Let's find a link. I click 6, here we go. So this gives us a link, but it does not have an archive URL. So what we could use is somebody that goes to an archival website and then puts an archive URL there, and then the archive date there, and then hit apply changes. If you're able to do that, that would be very helpful, because then we would not have to worry about those links going away, and they would be there immediately for people to use. If you're able to help consumerrights.wiki in this way, I highly appreciate it. Again, on this channel, you're not going to find me trying to sell you on random garbage. I'm not going to have random sponsored crap on this channel. My goal is not to use this channel as a platform to promote other companies' crap. I do not want to be a traditional influencer, but I would like to be an influencer in the way that I could get millions of people that watch this channel all contributing to these types of consumer protection databases, so that going into the future, we have less of these issues. If I'm able to influence even one of you in that way, then yeah, I would actually be happy to be called an influencer. I really want that word to mean something other than I am just here to try and sell you overpriced garbage that I don't even use myself because somebody wrote me a $3,000 check to do it. I want influencer to mean that we're all working on cleaning up our corner of the world and inspiring others to do the same. And admittedly, the activity on this website has kind of dropped since the peak, and I'm trying to get more people excited about it. So if you're excited about this, you'll make me excited as well. And maybe Blackberry. Not really, she's sleeping. See you in the next video. Bye now.